That's awesome.
All right, great. Welcome back to the House Committee on Government Operations and Military Affairs. We are picking up our work here with a look at S6 bill that I think is up in House Judiciary. And Ben, if you could introduce yourself and tell us a little bit about S6 and how it relates to our committee's jurisdiction, that'd be great.
Sure, my pleasure. Ben Novogroski from the Office of Legislative Counsel. I just did a walkthrough of S6 this morning in House Judiciary, so today is the day of S6 for me. I actually think that this bill is a perfect representation of the division of jurisdictions of the two committees. Really, I would say sections 1, 2, and 3 of the bill really relate to the judiciary's jurisdiction, which prohibits the use of threats, physical harm, and deceptive tactics by a law enforcement officer during the custodial interrogation of a person under 22 years of age, and establishes a rebuttable presumption that such statements are inadmissible in court. So that portion of the bill is squarely within the jurisdiction of House Judiciary. The part that is more appropriate for this committee is the second half of the bill, which creates a mandate for the Criminal Justice Council in consultation with others to create a statewide model interrogation policy applying to all persons with specific enumerated situations covered within that policy. So since it's under the auspices of the Criminal Justice Council's responsibility, it falls under the jurisdiction of this committee. So I serve at the prerogative of the committee and the chair as far as which direction you want me to go. I can provide sort of the historical arc of how this bill is in its current form. To give some context, I can do sort of a quick run through of the prohibition on deceptive tactics, deceptive interrogation tactics to provide some context, or just go right into the Criminal Justice Council's portion of the bill.
I think that it would be helpful to understand briefly the context, because most folks were not on GovOps last year when we took a look at S250, which I think was set in motion the subject matter here. And we also have 3 new members of the legislature on the committee too. So it'd be good to provide a little bit of context. I don't think we need to spend too much time going through the sections that are really judiciary, but it'd be good to just know how, to provide some context so we're not going deep into the Criminal Justice Council pieces without understanding how they relate to the others.
Sure. Well, so for context, Mr. Chair, as you alluded to, this sort of started out last year in S250, which was a much more comprehensive bill that touched on various aspects of law enforcement. However, the portion that became S6 started out as an outright prohibition on false confessions. No presumption that could be rebutted, just an outright prohibition for everyone that there could be no false confession elicited by a law enforcement officer during questioning. After that passed the Senate, there were some questions raised in the House about really what that actually meant. And essentially, that provision of the bill was turned into a study that the Joint Legislative Justice Oversight Committee examined over this past summer. After hearing testimony from representatives of the Innocence Project, the Defender General, and others, the piece of legislation that was recommended by the committee was the original form of S6, which was that prohibition of the use of deceptive tactics and psychologically manipulative tactics, which is no longer in the bill, for the use of, in interrogating juveniles under the age of 18. That has since evolved a bit since it's been introduced. The threshold age is now under 22 years of age, and that was after testimony was received in Senate Judiciary on brain development and how brains are not fully developed until about your mid-20s. And also the language about psychologically manipulative tactics was struck due to, for lack of a better term, sort of the squishiness of the terms used and really what does and for instance, it would be part of psychologically manipulative tactics would be providing key incriminating facts to the person being interrogated that they would then adopt, and how that could be sort of psychologically manipulative. And there are a lot of questions about really what the scope of that was, how it would work in practice. And so after a lot of testimony and debate, that definition was struck. And so all that's really left is deception, and the use of other threats, and the prohibition against those when questioning juveniles under 22 years of age. So that's sort of a summary of how the portion that's really under consideration, House Judiciary, where it currently stands. Another part of that evolution that the Senate Judiciary Committee discussed and amended the bill to include is the creation of a model interrogation policy statewide that would apply to all persons and specific scenarios of interrogation. So if you turn to section 4 of the bill, which would be on page, find it myself, it's page 6, thank you. So this creates a mandate that on or before October 1st of this year, the Criminal Justice Council, in consultation with the Attorney General's office, would have to create a statewide interrogation model policy applying to all persons subject to various forms of interrogation, including custodial interrogations occurring in a place of detention, so like a police department, custodial interrogations occurring outside of place of detention, so really anywhere else. And custodial interrogation, by definition, custodial means essentially the person being interrogated does not feel like they're free to leave, they're in custody. 3, that interrogations that are not considered custodial, regardless of their location, and then interrogations of specific individuals with developmental, intellectual, and psychiatric disabilities, substance use disorder, and low literacy levels. So that's not an exhaustive list, but the model policy would have to cover those situations specifically. Then the next step in the development of that model policy would be by January 1st of 2024, the council, in consultation with other stakeholders, which would include the Agency of Human Services, the Vermont League of Cities and Towns, the Human Rights Commission, and the Innocence Project, would update the model interrogation policy to establish a cohesive model policy for all law enforcement agencies and constables exercising law enforcement authority to adopt, follow, and enforce as part of their agency's or the constable's own interrogation policy. So that's the development of it. Eventually, this policy would be adopted, and then I'll get to this later on in the bill, by April 1st of 2024. You'll see that Section 5 is related to that adoption, that for those that don't comply with this mandate, they'll be prohibited from receiving grants or other financial assistance if they're not in compliance with the model interrogation policy established by the council. So that's sort of the teeth of it, if you will.
Representative Hango.
Thank you. Ben, currently, who holds this ability to create policies around interrogation for juveniles?
Many law enforcement agencies themselves have policies. For instance, I know the state police has a set of policies surrounding interrogation. There's been much testimony about really sort of what they do to train their officers, and also the peace method is sort of a newer policy that's been adopted. I believe it was in the last few years, maybe I wouldn't say any longer than 5, where it started out as a pilot program within the state police. I believe that they were teaching it out of Norwich to their officers, and then it was adopted by the police academy. So all law enforcement officers are receiving the peace method as part of their training. However, once they leave the academy, there's no real prohibition or uniformity amongst law enforcement agencies about their policies. And so Senate Judiciary, after hearing testimony, felt that this was a step. There was testimony indicating that this might be a step in the right direction to create uniformity amongst agencies, so that they have the same policies regarding interrogations. Does that answer your question, Representative Becker?
Yes, it does. And another question along the same lines in number 4, line 19. Why is substance use disorder spelled out or called out when really you're talking about someone's developmental or intellectual capabilities?
That was a policy choice within the Senate Judiciary Committee about just essentially accounting for situations where someone might be experiencing substance use disorder and accounting for that in the interrogation policy.
Yeah, I can have you elaborate a little bit more on that number 4 too. When that interrogation takes place, or I'm assuming a lot of times, not a lot of time in advance of an interrogation, whose responsibility is it, or how do they determine whether an individual has developmental, intellectual, psychiatric disabilities, low literacy levels? I mean, that's huge in my mind.
Well, I think that probably would be, and this would be, I can't speak to that effectively in my role. I think that's probably a better question for the law enforcement community itself. However, there was testimony this morning about that it's really based off of observation. And then presumably, and the reason why the Senate Judiciary Committee felt that the establishment of the model policy itself and the development as written in this version of the bill was effective is that you're essentially getting the experts together, the council, the attorney generals, other stakeholders to come up with different iterations and considerations that would have to go into the policy instead of it being sort of legislated, that you leave the experts to decide the contours of what that policy and the considerations within it should be. So I know that doesn't fully answer your question, but I think that is better aimed towards the law enforcement community about how they discern those traits.
Right, because again, I can see potentially holding someone for a length of time before that assessment is reached, if you ask me. I mean, is it somebody's, intellectual literacy level the issue, or is it because they have an adverse reaction to medications? Or, and again, I'm sure you're not the one to answer those questions, but it would be important for me to hear, just what that protocol might look like.
Sure. And again, without really answering that question directly, there are various situations that are contemplated in the establishment of the policy. And from the testimony, some law enforcement representatives have explained that, there is an investigation sometimes before a custodial interrogation, not necessarily just a questioning, right? So during that investigation, there might be evidence gathered about those individuals that they're going to interrogate that might help inform sort of what traits may apply to them. But again, I've still deferred to them, but that might be a way to help discern what that is.
Thank you.
If there aren't any other questions on the sort of establishment of the policy and about the sort of the teeth of the grant eligibility, moving on to Section 6, this codifies the policy itself. So once it's developed, it establishes that the council must create this model interrogation policy applying to the individuals that we've already discussed. And it must be done on or before April 1st, 2024, that each law enforcement agency and every constable who exercises law enforcement authority and who's trained in compliance with the applicable provisions shall adopt, follow, and enforce an interrogation policy that includes each component of the model policy that the council establishes. And everyone must comply with that model policy. On or before October 1st, 2024, and every other year after that, the council in consultation with the AG, AHS, the Human Rights Commission must review and if necessary, update the policy. So it's sort of every 2-year look to ensure it's up to current standards. as determined by those stakeholders. Then if you look in subsection D on page 9, this really goes into really training and adoption of the policy. So the Criminal Justice Council, again, in consultation with the Attorney General, shall review the policies of all the law enforcement agencies and constables that are required to adopt it and ensure that they comply with the model policy before April 15th of 2024. If the council finds the policy is out of compliance, they need to work with them to get it into compliance, and that still isn't effective. The model policy that the council creates becomes the default policy applying to those agencies or constables. And then finally, if you turn on the last page, subsection E says that the council must incorporate the provisions of this section into their training requirements. And then annually in subsection F, as part of the annual reports to the council, every law enforcement agency and constable who's trained shall report to the council whether they've adopted the interrogation policy and the council must determine as part of its annual certification of its training, whether current officers have received training on the interrogation methods outlined in the law. And then finally, annually on July 1st, the council must report to the House and Senate committees on judiciary regarding whether or not law enforcement agencies and officers have received training on these interrogation methods. I think it's notable that the structure of this adoption is modeled after, it doesn't mirror, but it's modeled after the adoption of the fair and impartial policing policy that the council adopted. The timelines are a little adjusted, but as far as the development and the mandates, it's a pretty close mirroring of that, just with some changes. And then section 7, you'll notice, was deleted. That was an appropriation that the Senate Judiciary Committee had put into the bill of $150,000 to the council for the creation of a director of policy provision. That was ultimately struck by Senate appropriations. If I recall correctly, there was testimony that there were some other appropriations that might cover this type of policy development. But I can't speak more to that because I just don't know exactly what happened with all the appropriations at that time. And then finally, the effective date, the bill takes effect on July 1st, 2023, except sections 5 and 6, which is the adoption of the policy itself and then sort of the enforcement mechanism, go into effect on April 1st of 2024. And that's really just to align with the date that the policies are to be adopted by the agencies.
So it sounds like judiciary is hearing from a lot of folks, including at least one law enforcement official today on this.
It has been a full day of testimony.
Yeah. So I'm wondering if if anybody has testified to the kinds of concerns we heard about timeline around, for instance, the domestic violence model policy that was in our bill. Was there any anxiety expressed about the timeline? It's pretty aggressive.
Well, I do know that representatives from the council did testify, did raise those issues, and I think the committee considered that, and I think part of it was, rather than legislating the policy just to be effective, they created the sort of rollout that you see here, in addition to providing that extra position to help coordinate this policy along with others that I believe this committee has contemplated creating. But I would defer to the council as the best entity to speak to any tension or opinion on that.
Yeah, because my one first reaction looking at this was just about that timeline. I just wanted to make sure that before judiciary passes the bill out, that they've just heard from both the council and agency leaders, maybe to talk to the LEAB as well, just about their ability to make sure that the model policy being disseminated and then being in effect on this 1-year timeline is going to work. I mean, it doesn't seem like it would be that complicated a policy, but I just want to make sure that everybody's aware that this is coming down the pike.
Yeah, and to that point, Chair McCarthy, I mean, starting at 9 o'clock, House Judiciary, and still to right now has been hearing testimony on this bill. I think this morning it was Defender General, the Innocence Project, who else? Many law enforcement agencies. That was sort of the afternoon. I know DPS is on there. Chief Judge Zone is testifying. I know that there are representatives from various police departments as well. I think 2 or 3 detectives are also testifying from those departments.
Falling where?
I'm sorry.
Falling on which side of whatever?
Yeah.
Well, I don't necessarily want to taint what the committee would consider. I don't view that as my place, but yeah, you can draw your own conclusions from that, to be quite honest.
Representative Hankin.
So first question is for you, Mr. Chair. What is our role in reviewing this bill?
So Representative Lalonde had asked me for us to just do a drive-through. I'm trying to get used to saying that instead of drive-by. So that we would just be aware in the context of our other work and to see if we had any concerns. And so I guess I would do at this point, since I don't think they're moving this today, would be to flag any questions or concerns that we have. So, my one thing that I will put is at the top of my email to him would be to make sure he's hearing about the timeline and whether it can be rolled out reasonably that fast. But it sounds like that'll be top of mind based on the folks I'm looking at that are testifying in there today. Are there other questions that folks have that we want them to zero in on?
I really am struggling with this concept of another group besides the police academy making policies that the police academy will then have to follow when they already have a program in place that appears to be working quite well. I also have problems with raising the age all the way up to 22, but I know that's not our committee jurisdiction. I'm just trying to get a feel like we're not going to have to take a vote on this in this committee, but I understand that if it's for our information, it seems to me that we are authorizing the Vermont Criminal Justice Council piece by piece to implement more and more, one by one, more policies that affect all law enforcement in Vermont. And I would imagine, I wasn't in on the creation of the VCJC, but I would imagine that that's the original intent of the folks who dreamed this up, that it is going to be the group that dictates everything that law enforcement does in the state of Vermont. And I'm just seeing more and more being given to their hands. And then when I look at the makeup of the VCJC, there is not a majority of law enforcement officers on that council, which concerns me. There are a lot of citizen folks who are on that council making decisions about law enforcement and about policies that likely have worked well for a long time. So I have a lot of concerns about giving more and more power to the VCJC, and I see this as just another bill on top of the ones we just passed through this committee that is handing over more authority to them. So that's where I stand on it. That's my concern about this legislation.
Duly noted. We have this body in the previous iterations did expand the Criminal Justice Training Council to have expanded authority, expanded membership, and we haven't, as this committee in our current form talked about but I think that the question of sort of their membership and their role isn't the question before us today, but I hear the concern. I think the pieces that that I'd like to be focused on in terms of giving feedback about this specific bill would be around, the capacity of the Criminal Justice Council, and the kind of just making sure that the work that we're asking them to do, fits in with the other work that we have tasked them with. But it seems like the development of a model policy is squarely in their wheelhouse as they're constructed. Representative Waters Evans.
I don't know if you can answer this or if this is just something I was thinking about, but I was going back to that section 6 where it says they have to establish a model interrogation policy that applies to persons, the various forms of interrogation. But then it says individuals with developmental, intellectual, and psychiatric disabilities, substance use disorder, and low literacy levels. I'm wondering if substance use disorder in that context more indicates somebody who's impaired in some way whilst being interrogated, as opposed, do you know what I mean? Or as opposed to someone who maybe has that condition, but it doesn't apply as a detriment necessarily in that moment when the interrogation is occurring.
Yeah, substance use disorder is diagnosed. So I think what you're getting at is whether or not if someone's just impaired in some way.
Yeah.
When they're like, say,
Is that part
pulled
of
over
that?
for DUI.
Yeah.
If they had substance use disorder and were impaired, I think it would be captured, but this really is just if they have an addiction, essentially.
Okay.
Yeah. I think that's that was part of the discussion, at least in Senate Judiciary.
Okay.
And the way that this is constructed, it's that the model policy is supposed to consider the interrogation of individuals that meet those criteria.
Okay.
Correct. It's supposed to, yeah, exactly. Consider that, potentially create policies around those very situations, but that's not necessarily an exhaustive list. It's not cabined by those. It's just as these are included in whatever the council and those stakeholders decide should be the model policy.
Representative Hickman.
Yeah, I think, as you mentioned, part of our purview also, I mean, they've taken out the amount of money for, sounds like $150,000. For somebody to take this on in the council, my understanding is. And so that goes to your time frame issue as well. And I certainly would wonder what council's concerns are, whether or not they could meet that without additional help. And I'm not saying that I'm supportive of the $150,000 to an additional person. We just gave them a few other folks and an attorney and everything else. So it's quite a growing group for sure. And but I think that goes to your timeframe issue as well.
Mm-hmm. Yeah, so I think the two key areas that I would raise as my initial things are the timeline and then the capacity of the Criminal Justice Council to do this, especially in light of those resources being taken out from the original bill. Any other questions? Yeah, Representative Morgan.
I think you agreed with that. I'll piggyback a little bit on what Rep. Hango said. I have some similar concerns. Also, I haven't had a chance to read this thoroughly, obviously, so I would need to be way more educated, but just kind of a blanket statement of, which goes, I think, piggybacks, like I said, on what she said, of enough other agencies other than law enforcement folks imposing theories, whatever input into the lives of policing to the point of I'm just getting concerned to some degree. Maybe I'm standing on the island by myself, but how difficult we already had with recruiting police officers. I just don't know if we're ratcheting so deep sometimes that, I don't know, that's just my overall, when I see this, I have to read it more thoroughly. So I'm going to reserve that ability to say more if we take it on further. But I always look at it with that eye to go. So we have to, obviously, if there's bad stuff going on in the policing world, we have to fix that, no question. Like any business, excuse me. But I just have that concern. I'll just leave that right there. Thank you.
Representative Hooper.
Same sort of situation. I've only read and heard about blah, 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 just gone through this once, but I mean, we're not living in the days anymore of a sock and a rock. Blackjack sort of thing. Would this, as written, if found that the officer who did the arrest and interrogation did not follow the principles, create a right of redress or appeal in a court of law?
Not in a court of law. The potential, I guess, accountability for a police officer that deviates from this policy would be with the council. It would probably fall under category B misconduct, the either gross deviation from a policy, either adopted by the council or by the agency itself. So that could be the basis of an agency investigation, or if it rose to the level of a council investigation and going from there.
And if that investigation happens, we could see a situation where there's at least a partial defunding of the police department?
No, I think, and you're talking about the grant eligibility,
Yeah.
and that would just be if they didn't adopt, follow, and enforce the policy. So it would be if the policy didn't exist, if the agency as a whole didn't follow it, and also if there was no enforcement of it. So I think that the way it's written, part of that enforcement might be if there is a complaint of category B misconduct against a agency's officer and they refuse to investigate. That might be considered grounds of a grant eligibility issue because they aren't enforcing the policy. But I think that's something that might be a good question for the council as well about how they would interpret that vision. But again, this language specifically mirrors the fair and impartial policing model policy. So it's not new language in our statutes.
Nothing would prevent a defense attorney from raising those issues, though, as a pushback on a confession.
So I think that's a little bit of a separate issue as far as the admissibility of the confession. Is that what you're getting at?
Yeah.
Yeah, and I think that's getting
dragged in.
right, but that's getting into the first part of the bill, which would be, was a confession of a juvenile in custodial interrogation elicited by deceptive tactics. If it was, then there's that rebuttal presumption that would have to be. So it would probably be, the way it would probably play out is after arraignment, then the defense attorney would be requesting, the cruiser cam or the body cam footage. Based off of that, would probably make a motion to suppress. And if this was part of that motion, then it would be litigated under the standards that are outlined in the first half of the bill. So if I'm understanding correctly, Representative Hooper, there is sort of a court process, but it is separate from what the council's involvement is in the bill.
Generally, again, caveated by, I've only read through it once. I don't have a real warm and fuzzy feeling about it.
Well, so I just want to be really clear that we're not weighing in here on the first half of the bill. The question that we had was about our jurisdiction, which is, to some of the points that have been brought up, there are some there are some concerns, but I think the general idea behind the second half of the bill, unless I'm mistaken, Ben, is like we've done with fair and impartial policing and with the domestic violence model policy, we're essentially setting things in motion so that if model policy is adopted and then it's violated, that could be considered a conduct that then the Criminal Justice Council could take action on violations of the model policy, but without having sort of a universal expectation of all law enforcement agencies to have this policy and to, have that expectation that in this case, interrogations are going to be carried out that way. There isn't a structure of accountability. So this is just sort of following that same path, but for this specific area of police, professional behavior.
Yeah, I'd say that's a fair interpretation of the bill.
Representative Hango.
Thank you. Because I am really far removed from judiciary, what part of this bill models, to use that word, the fair and impartial policing statute?
It'd be sections 4, 5, and 6.
So I guess I'm not knowing what the fair and impartial policing statute says about interrogation.
So I think what Ben, maybe to just help clarify Representative Hango's question, that it models fair and impartial policing. It's about the rollout of the timeline, the development of a model policy, and how that is phased out.
Yes.
But the content
Okay.
of what they're addressing is completely different. It's not
Okay,
interrogations.
that was my confusion when you said that it mimicked the fair and impartial policing.
My apologies on any confusion on that.
Okay. So basically what I said before, we did it with fair and impartial policing. We did it with sexual violence and domestic violence. We did it with something else recently. So now we're going to do it again with this new up to age 22 as a juvenile interrogation policy, right? That's what we're looking to do?
Well, so what it would be broader than that. So the model policy that's adopted would necessarily have to comply with state law. If this bill were to pass, part of the state law would be the juvenile interrogation aspect, which is the first part of the bill. But what the mandate does is that it has to create a model interrogation policy applicable to all persons. So not just juveniles under the age of 22, with those specifically enumerated situations that are listed. So custodial interrogations occurring in a place of detention. So people that are in custody in a police department. So what would be the interrogation policies in that situation? The council with the stakeholders would have to create that. What then for custodial interrogations occurring outside of a police station? What would be the model interrogation policies for that situation? And interrogations that aren't considered custodial. So ones where people are free to leave, potentially just questioning somebody on the street. What's the policy surrounding that? What are the guardrails potentially? And then finally, as we've discussed, for those specific individuals with disabilities, substance use disorder, or low literacy levels.
Okay, great. One thing you said that just sparked my attention. So would the concept of deception then apply to all other individuals irregardless of their age?
That would depend on the policy that's created.
So the VCJC will create a policy and they could say, no more, we're never going to use that tactic again.
Possible.
Okay, thanks. That's the answer to my question.
Okay, so it sounds like I have a couple of areas of concern and further interrogation into the bill that we should ask our colleagues in judiciary to do. So I will try to capture the flavor of some of the questions that we've raised here in a message to Representative Lalonde. Is there anything else the committee would like to ask Ben while he's here? Thank you very much, Ben, for bringing us the lowdown on S6. That is it for us today. appreciate everybody's hard work. We will things up tomorrow. I think we're at our usual 9 o'clock with us.